So the Bharatiya Nagrik Suraksha Sanhita marks a significant reform in the Indian legal landscape, aiming to streamline and modernize criminal procedure. So one of the critical area of change under this new legislation is a process for filing a private complaint to the court or the magistrate. Please underline the word private complaint to the court or magistrate. So the BNSS seeks to consolidate and amend the laws relating to the criminal procedure, replacing the Code of Civil Procedure. This comprehensive legislation introduces several reforms aiming to enhancing the efficiency and accessibility of criminal justice system. Notably, it emphasizes the use of technological and forensic investigation and legal processes. So this block deals with the key aspects of the procedure. First, we will come into 2H, section 2H, please underline.
Yes, ma'am.
So section 2H defines what is complaint. Okay, please make a note somewhere. It defines what is complaint. So complaint is an allegation that is made to a magistrate. Please underline. Complaint is an allegation made to the magistrate orally or in writing. Orally or in writing, with an intent of initiating legal action. With an intent of initiating legal action against a person accused of committing a crime. Unlike police officer, complaints are initiated by the individuals. Please underline. Complaints are initiated by the individuals rather than law enforcement agencies. Okay.
Yes, ma'am.
Now 223 talks about the examination of complaint. So upon receiving a complaint, the magistrate must examine the complaint and any witnesses that are present. Okay, so once you have written a complaint and given to the magistrate, then after that the magistrate will call you and they will examine you. Who has given the complaint will be the complainant and other witnesses. This examination is conducted under oath and substance of such examination is documented and signed by the complainant, witnesses and the magistrate. However, there are exceptions where the magistrate need not examine the complainant, such as when the complaint is made by the public servant or by a court. Okay, so this is the process that they have to follow. So once a complaint is registered, the magistrate or the judge will call the complainant and the witnesses and they will examine it whether the incident is true or not. Okay, for that. Then procedure by an incompetent magistrate. So if the complaint is made to a magistrate who is not competent, please underline the word not competent, to take the cognizance of an offence, the magistrate may either return the complaint or return the complaint for the presentment of appropriate court or direct the complainant to the proper court. This ensures that the complainant is heard by the magistrate with necessary jurisdiction. Now, postponement of issue of process. Please underline, this is also one of the important topic when we talk about criminal law. Okay. The magistrate upon receiving a complaint, underline. The magistrate upon receiving a complaint may postpone the issue of process against the accused. The magistrate can either inquire into the case themselves or direct the investigation by a police officer. Please underline. So the magistrate can either inquire into itself or may direct any other police officer to investigate the matter. Okay. The step is crucial for filtering out frivolous and baseless complaint. Please underline. This step is crucial for filtering out frivolous and baseless complaints and ensuring that only legitimate cases proceed for the trial. Next is dismissal of complaint. So after considering the statement of the complainant and the witnesses, that is by the magistrate. Okay. After magistrate will consider the statements that are made by the complainant and witness and the result of any inquiry and investigation, the magistrate may dismiss the complaint if there is no sufficient ground for proceeding. The reason for dismissal, must be briefly recorded. This provision safeguards against the misuse of legal system and ensures that the accused are not unduly harassed by baseless allegations. Okay. Now, if it is not dismissed, the next process will be issue of process. If it is dismissed, then the system will get over. For example, you are registering a complaint you are making a private complaint in writing to the magistrate, and the magistrate will call you. They will call you. They will inquire you. Okay, they will inquire you and your witnesses. Okay, they will examine you and your witnesses. After that, they will if there is no case made out, if there is no prima facie case made out, then they will postpone the process of issue, and they will just dismiss the complaint. But if there is a prima facie case, then what they will do? They will issue process. So if the magistrate finds sufficient ground for proceeding the case, they will issue a summon or warrant to the accused person. Summon means a written letter for the accused person to appear in the court, and warrant is through the police officer. They will arrest them and bring. Okay. The decision to issue a summon or warrant depends on whether the case is summon trial or warrant trial. This also we will read in ongoing classes. Okay, what is summon trial and what is warrant trial. The summon or warrant must be accompanied with a copy of plaint, ensuring that the accused is fully informed about the charges against him. Now section 228 talks about dispensation of personal attendance. So in case where the magistrate issues a summon, please underline. In cases where the magistrate issues a summon, they may dispense the personal attendance of the accused and permit him to appear through pleader. So they will tell that okay, the accused person personally need not appear on each and every day, but they can appear through the pleader, means their pleader must be present on each and every date. This provision is particularly beneficial in the cases involving minor offences, allowing for more efficient management of the court resources and reducing the burden on the accused. Now section 229, special summons for petty offences. So for petty offences, the magistrate may issue a special summon requiring the accused to appear either in person or through their pleader, or plead guilty without appearing before the magistrate. The provision simplifies the process for minor cases, allowing swift resolution and reducing the court's workload. So this is the process that is followed. Now in Gurudas Balkrishna versus CJM Goa, Chief Judicial Magistrate Goa. So in this case this happened. Next is Jacob Harlord Arana versus Veera Arana. So it is a well-known case of Jacob Harlord Arana versus Veera Arana. The Bombay High Court took a hard stance on section 204. Now it is 227 of BNS. The court remarked that the magistrate has a legal responsibility, underline, to conduct a careful study of charges and evidence presented to the court in order to determine whether there is a prima facie case or not. This must be completed prior to the issuance of summon under section now it is 227 of BNS. The decisions was accepted as a precedent, means the same judgment was accepted as a precedent in the case of Roshan Lal versus Hemchandran. So in this case, while issuing summon to the accused is a subjective satisfaction of the magistrate, it must be done judiciously in accordance with the law and on the basis of sound reasoning. Then one more case law is there.
Yes, ma'am.
Aham Charan Vehra versus State. So in the case of Aham Charan Vehra versus State, the Orissa High Court discussed that the power granted to the magistrate under section 228 of BNS, the Honorable High Court assured that section 228 of BNSS does not lay any hard and fast rule, underline the word hard and fast rule, to the magistrate must follow in exercising the conferred power, stating that the power is discretionary in nature. Please underline the word discretionary in nature. So the power is completely discretionary in nature. The court must exercise this discretionary power after due consideration of relevant circumstances, such as significant inconvenience that is caused to the accused, his or her profession, and so on. The magistrate dismissed the petition in the current case, which has been ongoing for 16 years, underline, owing in absence of the accused, which could not be confirmed despite multiple warrants given to him. So even after issuing multiple warrants, police searching in for multiple times, that person could not be traced for 16 years. Then it was determined that the magistrate's discretion in denying the petition in this matter under section 227 of it is 228 of this code was not observed. Okay.
Yes, ma'am.